So my name is Mike Macomber. I'm a partner here at Tully Rinckey. I'm also our chief executive officer, and my background is largely labor and employment law in a multitude of fashions. Honestly, anything involving someone's job, I consider to be employment law, and the areas in which we have help, with pretty much the exception of workers' compensation. That's not really employment law in my definition. Anything else, though, under the sun, we do. Now, by way of history, I started with the firm approximately 15 years ago. And why that is relevant is that was the heyday of what we call Butterball claims. Butterball claims were a series of claims that really founded the firm here, in which we represented tens of thousands of federal employees who were claiming claims of denial of military leave based upon the seminal case Butterball. And this lasted for probably the better part of maybe half a dozen years, something like that. And we really litigated these cases through and through, all the way up through the Fed Circuit multiple times. And why that is relevant today is the Feliciano decision, which I'll talk about in a few minutes, is an extension of those early Butterball claims. Now, the Butterball claims were all filed under the Uniformed Services Employment's Rights Act, and this, as we call USERRA, is the backbone of what, any kind of claim for benefits, seniority, reemployment, you name it, for reservists. The recent decision in Feliciano versus the Department of Transportation is one of only maybe 24 Supreme Court decisions that involve USERRA or any of its predecessors. We see these decisions probably once every 10 years. I think the last one prior to this was Staub v. Proctor, which was right around 2012. I might have missed one in between. But what is rather compelling about the Supreme Court decisions is they are almost always in favor of veterans and are almost always in favor of reservists. And what I love about this is it really, supports the liberal construction under USERRA that we are constantly arguing for in its interpretation. Now, what we're going to talk a little bit about today is determining the different types of pay or leave that may come into play when it comes to federal employees. And largely, we're talking about federal employees today. There's a whole realm of private sector USERRA claims that we can talk about at another time. Understanding of kind of current and past decisions as to what got us to where we are today, and more importantly, how we can help reservists going forward who may want to file a claim in the future. Brief overview of the Feliciano decision. Feliciano was a FAA air traffic controller. And what had happened was he had been called to active duty and requested the 22 days of additional military leave that he's entitled to under 5 U.S.C. 5538. Now, what has been a point of distinction with the agencies are what types of leave qualify for this differential pay. And the court's decision in Feliciano hinges upon the fact that to receive the differential pay, you must have been serving in support of contingency operations, declared national emergencies there. Anybody who's familiar with the military, we have been under support of contingency operations or threat of national emergency since 9/11. So almost all military orders qualify for that. Now, where that gets confusing, a lot of reservists, when they get called up, they may be just serving across the street. They may be serving in another state, but they're not flying to Afghanistan for a 2-week tour. Some are, but the agencies were trying to argue that not all those orders were in support of contingency operations. And the Supreme Court clarified that basically all those orders are. If you as a reservist are leaving your federal civilian job to replace somebody else, who then is going off to support the contingency operations, it's all interconnected. You cannot parse that out. And why that is so relevant to these claims is hundreds and hundreds of these O'Farrell claims, which I'll touch upon in a second, were denied previously because they couldn't prove that causation or the connection to the contingency operations. So in our minds, this is opening up the door for thousands of federal employees who have served in similar capacities over the years to potentially recover additional compensation that they may not have otherwise applied for in the past. I mentioned two other prior cases. I touched a little bit on the Butterball claim. The Butterball claims, we'll come to a second. That goes way back. O'Farrell was decided back in 2018, and this also involved some additional leave involving, I believe it was, I want to say, yeah, Michael O'Farrell. There's too many Michaels in the world. So Mr. O'Farrell had asked, similar to Feliciano, for additional paid military leave while he was on orders. And this was not the Supreme Court, but the court's decision in that time provided that leave for them. Now, in Mr. O'Farrell's case, it left open this whole issue of the contingency operations, and that's what we've been dealing with since 2018. Now, what is very helpful in those cases, it formed the backbone of what we are talking about today. And really what we're looking at is how are we going to prove what are those claims and the benefits the employees are entitled to. What we have been doing is requesting military records on behalf of a lot of these employees, because one of the wonderful benefits of USERRA is there is no statute of limitations. The only argument against bringing a claim under USERRA that is too old is latches. And last I checked, that's not a really good affirmative defense. There's been some case law out there that, waiting 20, 30 years, you might have a good claim under latches. But other than that, these claims are sufficient going back to the early 2000s. So anyone who may have served, any federal employee who may have served on active duty at any point in time between 2001 and the present may be eligible to seek reimbursement there. So as I said, what we've been doing in doing this is seeking out the military records to prove when, in fact, these federal employees were on military leave. Now, I mentioned previously with the Butterball claims, under a separate statute, federal employees are entitled to 15 days of paid military leave. And that is kind of step one for anyone who is going on active duty orders. Those 15 days of paid military leave, is what really formed the backbone of the Butterball claims. And that then led into O'Farrell's claims that once he had exhausted those 15 days, seeking the additional 22 days of leave on top of that. So it's important when we get these military records to calculate what type of leave the individuals are entitled to. After Butterball and O'Farrell, it's been very clear that the federal agencies are required to compensate the employees either by restoring their leave or, if they're no longer with the agencies, paying them for the equivalent leave that they would have received had they still been employed. This is we've seen claims in the past that, people who've served on military orders years after years after years may be entitled to dozens, if not hundreds of days of paid military leave based upon their records. Now, getting back to the Feliciano decision a little bit, what we're really talking about here is differential pay under Feliciano. And that really is the difference, the delta between what the employee was making as a civilian employee and what they were making in the military. And that is very important because for employees that are making more in the military capacity, you're not going to have that same argument when it comes to differential pay. If you have a federal employee that, say, is a GS-12, GS-15, that is, somewhere in that range, but they are, entry-level enlisted member, they will have a much larger gap when it comes to that differential pay. And so that's really one of the second steps we look at. Number one, were they on military orders? And then number two, are they even entitled to differential pay? And I've seen plenty of claims where the employees, they've submitted and say, well, actually, I made more in the military. Now, there is an open issue when it comes to all of the additional benefits that military members receive. I think there is a compelling argument that things like BAH and other benefits are not included in that definition. We don't have a lot of clarity in the case law right now as to whether that applies, but we are pushing that issue as well. I think it's basic pay to basic pay, and that should be the calculation that is used there. It's something that we're going to continue to litigate on as we go forward there. So we Here at Tully Rinckey, we are trying to make it as easy as possible for the reservists to do that. As I said before, when we filed the Butterball claims, we handled tens of thousands of applications, and we probably filed, half as many of those, once we received those military records. But the first step is contacting us to figure out whether or not somebody does in fact have a claim. Brittany will give you some information later on. We have a lot of intake on our website. We have military leave landing pages where you can submit, an intake and inquiry online. At which point we will reach out to you. We will go ahead and request the military records on your behalf, as well as leave an earning statements to determine what are the extent of your damages. Did you receive the differential pay? Did you not? After that, for federal employees, claims of USERRA violations are filed with the Merit Systems Protection Board. These, the MSPB, as we call it, handles all kinds of claims for federal employees, including discipline, whistleblower violations, things of that nature. But claims of USERRA violations for federal employees also get submitted to the MSPB. There's some standard forms and documents that, again, that we here at Tully Rinckey prepare on behalf of the employee. And these cases typically go in front of an administrative judge who will then issue an initial decision. Many of the agencies realize the mistakes that they've made. A lot of them was not intentional. They weren't aware of some of these things. So they are very prone to either settle or try and resolve the claims prior to a hearing. But if necessary, you can go to a hearing and present records and evidence on your behalf. Now, there has been a lot of discussion in the media and the news. The Merit Systems Protection Board currently does not have a quorum. The MSPB board, the higher level authority of the administrative judges, is a 3-member panel. And to have a quorum, for them to have the ability to make decisions, require at least 2 out of those 3 seats to be filled. Right now, we only have 1 member, so they are lacking a quorum. This happened during the first Trump administration, lasted about 18 months, I believe, maybe 24 months. It just means it slows down the appeal authorities or appeal options for federal employees. What we do instead is you have to go to the federal circuit instead of going to the board. There are still appeal options. You can still file claims with the MSPB. Administrative judges can still render decisions in favor of the employees. You just really lack that ability to file an appeal with the board itself, or at least I should say, you can file the appeal. You're just not going to get a decision anytime soon. Last time the board lacked a quorum, it took anywhere from 3 to 4 years for them to render a decision due to the backlog. So even though that they don't have a quorum right now, it shouldn't dissuade anybody from still filing a claim. The offices are still open. If not, they're busier than ever, and they are still issuing decisions on behalf of employees. The fun part. Now, Brittany earlier on, I think gave a heads up. We have a lot of the lines muted right now. If you have any questions, you can send those to Brittany. She'll send them over to me as WebEx as well. We received a number of pre-submitted questions over the last couple of days. I'm going to go through those. I'm not going to be able to touch upon a lot of these questions. Some of them involved confidential information or individual claims. Obviously, I'm not talking about any of that here today. If you have a question about your own personal individual circumstance that I did not touch upon today, I encourage you to reach out to us here at Tully Rinckey. We'd be happy to set up a confidential consultation to go into a little more detail with you. First question I have that I think is applicable to everybody, and I think this is a great question. Can I claim differential pay when I get out of active duty, or do I need to while I am on orders? You can ask for the differential pay at any time. A lot of agencies try and hide behind the fact that the individual never asked for the differential pay. Quite frankly, you can ask today. You can ask tomorrow. You do not need to do it beforehand. Obviously, it's probably better to, going forward for people who are looking for these types of benefits. It's always best to do it ahead of time. But the arguments that we've made with the Merit Systems Protection Board, even filing the appeal itself can be considered a request. So no, you do not need to do it while you are on orders. You submit the orders, you submit the forms there. The agency should be following up at that point in time. The second question I thought was really applicable to everybody. Does this differential pay cover the entire 15 months I was deployed, or just 2 to 3 weeks? So it's interesting. The 22 days of differential pay applies on a calendar year. And so if this person was gone for 15 months and that bridges 2 calendar years, you would be able to claim 22 days in 1 year and 22 days in another year. So I've seen some of these claims where somebody went on active duty in October and came back in April. You could claim the 22 days in, let's say, 2024, and then you could claim another 22 days in 2025. Now, if the period of military service was all in the same year, you went on military orders in April and you came back in October, in that scenario, you would only be able to claim the 22 days. So it's all based upon the calendar year itself and not necessarily the duration of the leave. This question's a little bit broader, and that is, how do you calculate a claim for a 17-month activation from 2007 to 2009 with a GS7 to an E6? I think this claim is very interesting because you get into the comparison of a GS7's pay and that of an E6. Now, off the top of my head, the differential pay on that may not be very large, and if anything, the military pay could be higher. What we do is we look at the OPM pay tables. All of this information is public information. You can pull it up. We have it all readily accessible on our end, and then we just take a look at it. Okay, you're a GS7 step 7, you're making X amount. If you are an E5, you're making Y. If that GS7 pay is higher than your enlisted pay, then differential pay would apply. If the reverse is true, if you're making more in the military, you may not be entitled to the military pay or the differential pay. One question that was asked here is, what if the employer changes their policy from offering differential pay while you're on active duty? What are your rights? I'm guessing that this is somebody that was in the private sector. I want to be very clear. What I am talking about today is with respect to federal employees. USERRA still applies to the private sector, and there are some states that have military pay laws in place. I know Illinois does, New York does, Massachusetts, I believe California. I think there's 16 or 18 states that have military pay laws that protect their employees as well. But USERRA is a federal statute and applies to every state. If you are a private employee working for any kind of private institution or working for the state in which you live, there may be benefits to which you are entitled to, but nothing we're talking about today really applies to that. If you have questions about that, certainly reach out to us. If we have attorneys licensed in those jurisdictions, we're happy to answer those as well. Another great question that I think applies to everybody here. What if you are no longer employed by the federal government? Are you still eligible for this benefit? And the answer to that is yes. You can still apply for those benefits. We've dealt with this with Butterbar 1. The first time we dealt with Butterbar, I would say 50% of them were retired. I may have made that number up. That may have been based on my own personal experience. But half of the claims I dealt with were current employees, half the claims were retired employees, at which point in time you would just get a check cut to you individually as opposed to any kind of restored leave or anything of that nature. Sorry, last question I thought was good. Very long one, so I'm going to read this a little bit slower here. Whether or not civilian employees will now be entitled to differential pay upon being ordered to training that will ultimately support a national emergency. For example, a federal employee who's currently not a reservist but wishes to enlist and then is ordered to basic training. Will the employee be entitled to differential pay during basic training and MOS producing training? Again, it's the orders themselves. If you are ordered to active duty, you would be eligible for those benefits there. It's the military orders themselves. And again, that's why it is very important when we file these claims, we always request the military orders themselves to ensure that you are in fact covered there. So you may be entitled to the differential pay as well if you are not currently in the reserves, but you are looking to do so in the future. I'm going to give it a minute to let Brittany catch up and see if there's any other questions online. If you do have any other questions, certainly feel free to reach out to us. If I may have skipped over one of your questions because, again, I kind of deemed it to be a little too personal, certainly reach out to us. We're happy to talk to you. We're happy to set up a consultation. One question here. Would this affect your TSP agency contributions? Interesting. There are provisions. So a separate section under 38 USC, I think it's 4318, deals with pension and TSP contributions while you're away on military orders. You may be able to seek additional contributions for that if you are entitled to that differential pay. There are separate provisions regarding basically the equivalent of 401k and retirement TSP contributions there under 4318, I believe it is. So I hate to give you the lawyerly answer of it depends, but it does depend a little bit on whether you make that election when you come back. The agency can't force you to do it, but if you do elect, they then will be required to do any kind of matching contributions and things of that nature. And there's a whole calculation that people with CPA degrees are much more inclined to figure out than I am. Well, like I said, I wanted to provide a very top-level overview of these claims here. There are literally hundreds and hundreds of ways in which USERRA can be applied. Here at Tully Rinckey, we were founded by our founding partners are both retired military. We have represented thousands, if not tens of thousands of federal employees and private employees in claims of USERRA discrimination. Personally, it's one of my favorite areas of the law to explore. If you have any other questions that might apply to you, feel free to reach out to us at tullylegal.com. You can reach us at 518-218-7100. If you would like more information about filing a claim yourself, you can go on our website. There is a military leave landing page with an intake form right on there. There's a couple of easy little questions, and we'll send you all the papers and documentation you need to initiate a claim on your behalf. And I'll add, just because I don't think I said it before, we do this with no upfront cost to the federal employees. We will only charge if we prevail against the agency. We have several claims going right now, including some class appeals that we are looking at to try and file these claims on behalf of everyone. If you need more information, please feel free to reach out to us, and we look forward to hearing from you. Thank you very much.